Ora tēnā katoa rarau mai nei ki roti tēnei paremata nei o tatau, te paremata o Aotearoa no reira nau mai ara mai. Te urunga tapata Māori tū, ngā nuku tū, ngā rangi tū, ngā waka puritia mai waka, tāwea mai waka. Ora tēnei te Māori ka waka piki, tēnei te Māori ka waka kaki, te Māori o tēnei tupuna, te Māori o tēnei āriki, te Māori keirunga, te Māori keirangi, te Māori kāputa ki te waiau ki te ao mārama. Ka puta ki te waiau ki te ao mārama ki koutou e ngā mātāwaka o ngā tai ewa. Nau mai, ara mai. Ngā tai ewa o roto o Aotearoa, ngā tai ewa o te ao, o te kāwea o nau mai, ara mai ki roti te wanga nui atara, kei raro te pare rau o tō tātou piringa ware, te ware pare mata nei. Nō reira nau mai, ara mai, kei raro i te pare rau, o te upoko ariki, o te ture, the Honourable Chris Finlayson, ki aia ki te ara mai o tino rā e kaupapa anō tāna, me tōna taumaa, me tōna ua. O tino rā i konei, i taumai i konei, the Honourable Chester Burrows. Nō reira tēnā koe e te minita nau te matakanohi mo tēnei kātui. O tia nō rā, ta uri atu rā ki te tō kōrero eke, te tuatahi tēnā koe the Right Honourable Dame Shona Elias, tēnā oku. Koutou e ngā māngai kōrero. Ka oki atu rau ki tēnei kātū waiata. Uti pārore ko te mai ua, ko te mai teitei, e kerea ana i te ao. O tino rā ko tēnā kātū waiata, e waiata ka uaki ana i waka puare mai te papa, i waka puare mai ngā kōrero e pāna ki ngā tikanga o te ture. Nō reira kia koutou e kērea atu nei, kērea mai, kōrero ea mai, wānanga ea mai, a koko ake nei, ka puta ngā ua, ka puta ngā onge ka mea mo te ano. Nō reira kare te kumiaro, ko te mai ua, e kere ana te rori pauri ana ia au. Nō reira tēnā koutou. Ladies and gentlemen, nau mai haramai. Welcome to Parliament. Kei raro i te pare rau, under the mantle of the House, and under the mantle and the hosting Minister, the Honourable Chris Finlayson, and the Honourable Chester Burrows. Just want to share with you that little ditty. A ditty is a little bit of poetry, which is a ditty that was often performed in one of our gardens known as the Umumamaku out in the Hutt Valley. But it talks about the hard work and about unearthing things when digging. And sometimes when you dig, you find unusual things. So nō reira koutou e te unga mai ua, e kerea ana to unearth. Tēnei mea i ngā onge kōrero o ngā tikanga me ngā ture, of the constitutional traditions. Nō reira tēnā koutou, kia ora tātou katoa, ka hori.
Kia ora mai tātou, tēnā tātou katoa. Well, those of you who are looking at me and thinking, gee, Chris Finlayson's put on weight, gained in stature, if looking 6 months younger. My name's Chester Burrows, I'm Minister for Courts, and in Legislative Committee this morning, Chris said to me, what are you doing at 9:15? So this is what I'm doing at 9:15. I'm sorry that he can't be here. He's tied up within the Privileges Committee that's going on at the moment. I've checked his speech. There's not a whole lot of invective. I'll read to the end. No one's dead. There's not a whole lot of obscure Shakespearean quotes or Latin phrases, so I'm going to steal it and pretty much deliver it as if it is mine. I feel very privileged to be here, and looking out amongst you, I see a room full of old lecturers or judges that I've looked up to over time, so sort of feel like I'm in the wrong place, or sooner or later you may, well, as we did in Parliament the other day, hold up some scorecards and give me marks out of 10. But I'm glad that you're here, and I hope that you find the day fruitful. And looking through your program, there's lots that I'd like to come and sit into as well, but unfortunately the whips would have something to say about that. The question of our constitutional traditions goes much further than examining our inheritance from Britain, and certainly goes further than just examining the Treaty Waitangi. From looking at the program, I think that this conference avoids the Eurocentric focus from which some other conferences suffer. And I think Maori thinking about these topics is often under-emphasised. That certainly cannot be said about the topics for discussion over the next 2 days. I think sessions 3 and the Johnson-Stevens papers look especially interesting. The early cases and stories of colonial New Zealand, which are now being rediscovered through work like Richard Boast's, which he is presenting in section 2 today, and Victoria University's Lost Cases project, is of significant historical value. I also think it is time to digitise Hansard. Who would have thought Chris would ever say that? I bet he didn't write this. The United Kingdom has done so, and I don't see why we shouldn't. The appendices to the journals of the House of Representatives have been digitised, so Hansard seems the next logical step. Easier access to legal and parliamentary history will lead to a better understanding of our constitutional traditions. I should mention recent exchanges between the executive and legal profession on a number of constitutional matters. There is an unfortunate tendency for some commentators to claim democratic freedoms are being trampled on in response to any executive decision with which they do not agree. I think on closer analysis, many of these criticisms turn out to be unfair. But I do acknowledge the differences in opinion on some recent matters. The vast majority of the profession makes a valuable contribution to public debate, although I would observe that those with the loudest voices or most pronounced opinions do not necessarily make the most valuable contributions. I prefer the approach of people like Professor Andrew Geddes, who, my cousin, the Attorney General, wisely appointed to the Legislation Advisory Committee, because I admire his scholarship and intellectual honesty. And while I may not agree with some of his commentary, see for example his May 2013 blog post, I think National just broke our constitution. He engages rigorously on legal issues and avoids hyperbole. Constructive debate can emerge from that type of approach. And that leads me to another point. I think the quality of debate improves when constitutional matters are dealt with in an applied form, rather than purely theoretically. I think the debate about the recent GCSB legislation suffered from the fact that much of it did not relate to the provisions of the bill at all. The question of how to fix the disastrous 2003 legislation was ignored by nearly all submitters, and that was lazy thinking. Rhetoric can never replace cold, analytical thinking. Public law is not political science. Public law does, however, benefit from historical investigation. Present debates are made clearer. Modern questions of public law are given a deeper context, and ultimately we acquire a deeper understanding of our country. In another life, I would have enjoyed sitting through some of today's sessions, but duty means I cannot do so today. I'm looking forward to reading the papers on a number of topics for discussion over the next 2 days, and I wish you all the best for your conference. Thank you, ladies and gentlemen, and I'm sorry that I have to depart so quickly myself, as does Chris. And for those of you who have noticed the differences in dimensions, although you haven't had Chris's colourful presentation, you've got more MP for your dollar. Thank you.
Kia ora tātou katoa. For those of you who don't recognise the bells, that's the sounds calling the MPs into the House, and what an appropriate note for this conference to begin on. I want to thank Kura for his very gracious mihi, and the Honourable Chris Finlayson QC in absentia for kindly agreeing to host this event in Parliament, and of course Minister Burrows for his wonderful introduction. I'm Claudia Geiringer. I'm the Director of the Centre for Public Law. I'm just going to say a few very brief thank yous and deal with one or two administrative matters. First of all, and very importantly, I want to thank the Law Foundation for their generous support of this event. They've supported us in a number of different ways. First of all, they've assisted with the costs of the out-of-town speakers, and that's what's helped us to keep the registration cost really quite low for this event. But they've also paid for student delegates to come to the conference from the law schools around New Zealand, and I'd like to say a special welcome to our law school delegates today. The other thing they're paying for is to have the 2 keynote addresses live streamed around the country, so another way to try and get the product of this conference out to as many people as possible. So we're very, very grateful for that support. As many of you know, the Victoria University of Wellington Law School has had very generous support from the Law Foundation over many years for a number of its endeavours, and we're always immensely grateful for that. The second acknowledgement that I want to make is of my colleagues Mark Bennett and Joel Colon-Rios. This conference is very much theirs, both in conception and execution, and I think they've put together a wonderful event, and I'm very proud as the Director of the Centre for Public Law to be associated with it. But behind every creative academic is a pragmatic administrator who actually knows how to make things happen, and in this case that administrator is Anna Burnett. I hoped she'd be in the room so that I could just show you her, because she is the person who will sort any problems you have out, but she's sort of floating around probably sorting out problems as we speak, but she's the person with the long straight hair that would have welcomed you at the registration desk, and I would thank her copiously if she was in the room, because she's the person that's actually made this happen. Some practical matters. First of all, the toilets are sort of there, right through that door, or you can go round the back and through. Secondly, you'll find in your package of information in case of emergency, and I thought just for the out-of-towners who, I know one or two of you were feeling a bit anxious about coming to Wellington given our recent shakes, that I would just remind you that there is more information about evacuation and so on that sheet, but in case of earthquake, drop, cover, hold, and stay away from the windows. But we can assure you that nothing that we've been through in the last couple of months has really been at the level where there's been any possibility of endangerment to life. So don't be anxious, and you're in one of the most earthquake-proofed buildings in the country. There are also maps in that booklet. There's a map to show you how to get to the dinner for those of you who are coming tonight, and there's a map just of the general location. If any of you haven't signed up for the dinner but are sort of wishing you had, there are actually a few places still available. On a first-come, first-served basis, you just need to let Anna know that you'd like to come, but please do that as soon as possible if you would like to come to the dinner. Cell phones, you might want to remember to switch them off. I only just remembered to switch mine off, so maybe do that now before the opening address. And the last thing I wanted to mention is that there are some written copies of the papers that Anna has available. We've sort of assumed that many of you are moving now into the sort of electronic world and will prefer to have them either in electronic format or to have printed them out in advance. But for those of you who, like me, are still sort of stuck in the hard copy format, Anna does have copies available of papers that have been made available to us. The theme of the conference, as you know, is Unearthing New Zealand's Constitution. We're very fortunate in New Zealand to have a Chief Justice who is not afraid to engage in a bit of constitutional excavation herself, both judicially and extrajudicially. I can think of no one more appropriate to give the opening address at this conference. She needs no further introduction, so without further ado, I'll hand over to the Right Honourable Dame Sian Elias.
Ena mana, ena reo, ena rau rangatira. Tēnā koutou katoa. Kura tēnā koe. And thank you for that wonderfully crafted waiata. So relevant to the themes of this constitutional excavation. I'd like also to acknowledge this beautiful room, because I never come into it without remembering how much of our history has passed through this place. I've been in many events which have taken place here, sometimes garbed in that ridiculous costume that we affect for the state opening of Parliament, and which so far I haven't been able to persuade my colleagues to jettison. But my most vivid memory of this room is when, following the New Zealand Māori Council case, it was made available to Māori to hold a meeting to discuss what should be done when the Court of Appeal sent us away to negotiate with the Crown. And I also have a vivid memory of a flurry at the door and the Speaker turning up and saying to the Chair, Sir Graham Latimer, "We've got the mongrel mob outside." And the mongrel mob came and sat over there, in fact, a group of them, and sat very quietly for some hours, and eventually they stood up and said they would like to be heard. And Sir Graham said, "Yes, of course, what do you want to say?" And they stood up and they said, "We just want to say that we thought you old people were mad going to the courts, but we were wrong and we're very proud of you." So that was a constitutional moment that I think about in this room. When I was first appointed Chief Justice, Sir Geoffrey Palmer, whom I'm delighted to see here today, told me firmly, I think he might have resiled from this since, but he did tell me firmly that part of my responsibility was to get out and talk about the Constitution. Now, all of you will know it's very hard to resist Sir Geoffrey, particularly when he speaks to you very loudly about these things. So I've tried obediently to do as he said. Very often I receive blank or puzzled looks or slight embarrassment. Once I provoked an editorial in a minor publication that said something like, "When a Chief Justice starts to talk about the Constitution, you know things are really bad." For that writer, talking about the Constitution was the equivalent of the judges going to the mattresses. The Godfather. Sometimes talking about the Constitution has got me into trouble. A constitution is concerned with the distribution of government power among the organs of the state and with the limits and checks on that power. And talking about the separation of power or limits or checks makes some people nervous, as does the idea that the constitution may be law rather than political, and that it has values as well as dogma. Some of this, of course, may be the result of the absence of a constitutional text, which is foundational, although since no text can capture a living constitution, our constitution is not unique in requiring us to look beyond the text. Of course, we do have some texts of our own that can rightly be said to be constitutional, but they are so scattered and incomplete that they are hardly a starting point once you get beyond the acknowledgement of the working parts of the Constitution which are to be found in the New Zealand Constitution Act 1986. That Act, as you will know, replaced the 1852 Constitution Act of the Imperial Parliament, which quite unbelievably really, had continued in place despite the huge changes in the 130 years of its existence, which made the text seriously misleading. I was really dumbstruck a few months ago when I was at the Commonwealth Law Conference in May, which was held in South Africa, to hear an eminent constitutional scholar praise New Zealand as a stable democratic society, which I was happy to accept, and to hear her say that New Zealand had one of the oldest constitutions in the Commonwealth. She was referring, it turned out when I quizzed her afterwards, to the 1852 Act, since the text she had consulted had missed the advent of the 1986 Act altogether. Well, I think that was pardonable because so did most of New Zealand. Only 8 submissions were received by Parliament on the bill, on the 1986 bill. The 1986 Act was really a tidy-up. The Constitution itself had long moved on. But the South African academic who praised the stability of our Constitution was not inaccurate to describe it as old. The Constitution of today is the organic Constitution developed out of the model we inherited with representative government and perfected with independence when we finally decided to cut the apron strings. That severing of the connection, it will be recollected, took place 15 years after enactment of the Statute of Westminster, and long after, as John Beaglehole says, we had become something of a nuisance and an embarrassment in London. While I think some of us may remain proud of the antiquity of our partially inherited constitution, few New Zealanders would, I think, exhibit the sort of meritorious proprietorship expressed by Mr. Podsnap when he told the mystified French gentleman, "We Englishmen are very proud of our constitution, sir. It was bestowed on us by Providence. No other country is so favoured as this country." Well, Providence has had nothing much to do with the constitution either of the United Kingdom or the parts of the constitution of New Zealand which are derived from it. The other parts, the non-British derived parts, are not so well explored, and it's one of the great virtues of this conference that it will do so. But the English parts are shaped by old conflicts and their resolution and shifting social circumstances with a dollop of political theory and legal doctrine thrown in. As Walter Bagehot once said, there is a great difficulty in sketching a living constitution, and that is that the object is in constant change. And that's true also of constitutions with rather more and more accessible written text than ours. But in a constitution as diffuse and contestable as ours is, it means we have to work harder to know and operate ours, an exercise I like to think of as muscular constitutionality. Stephen Sedley once said famously about the British Constitution that if we ask what are the governing principles of the arrangements and how their legitimacy is derived, we find ourselves listening to the sounds of silence. I don't think we should be as pessimistic as that. The outline of our Constitution is to be found in statutes and in ancient charters, including, of course, the Treaty of Waitangi. The 1986 Constitution Act acknowledges the different branches of government. The New Zealand Bill of Rights subjects all 3 of them to fundamental values. The electoral legislation protects the machinery of democracy. The Supreme Court Act identifies New Zealand's continuing commitment to the rule of law and the sovereignty of Parliament and affirms the importance of the principles of the Treaty of Waitangi. Some of these provisions identify values in the Constitution, some are value neutral. As in Australia, the United States, Canada, and all countries with written constitutions, values have to be identified as implicit in any constitutional text in order to make it work. Such values are behind the important constitutional conventions which shape some of the more important elements of the Constitution, such as what Walter Bagehot called the efficient secret of cabinet government. Values are also behind the habits of institutional behaviour that are essential to constitutional observance. It is a mistake to see a constitution as a system of rules. It is equally a mistake to see a constitution as shaped by theory, although theories do exert a powerful pull. Maitland posed the question, what is constitutional, at the end, not at the beginning of his lectures on constitutional history. His view was that the constitution of a country can be discerned only from its general law and its history, and only as a snapshot at any particular time. What he said was a classification of legal rules which suit the law of one country and one age will not necessarily suit the law of another country or another age. One may perhaps force the rules into the scheme that we have prepared for them, but the scheme is not natural or convenient. Only those who know a good deal of English law are really entitled, he said, to have any opinion as to the limits of that part of the law which is convenient to call constitutional. Constitutional observance depends on a constitutional culture based on shared principles and values. Where does such a culture come from? From what happens? From our history. And that is why this conference is to be so welcomed. The topics to be addressed are grounded in what has happened in our history or what can be unearthed from it, on the experiences that have shaped the New Zealand Constitution of today and from which the Constitution of tomorrow will evolve. And I'm looking forward very much to hearing the speakers address it. Thank you.
My name is Mark Bennett and I'm a lecturer in law at Victoria University of Wellington Faculty of Law. And it is my great pleasure and privilege to introduce our first Law Foundation keynote speaker for this conference, Professor Andrew Sharp. Professor Sharp is Emeritus Professor of Political Studies at the University of Auckland. He was born in New Zealand and educated at the University of Canterbury and then at Cambridge. And for many years he taught political philosophy and the history of political thought and published a number of important contributions to these areas. Since 2006, Professor Sharp has spent most of his time in one of the ancestral homes of our constitutional traditions, London, England, where he is a research fellow at Birkbeck, University of London. There he has continued his studies into the history of political thought, researching and writing a book on the founder of the first Christian mission in New Zealand, the Reverend Samuel Marsden. He has returned to New Zealand to undertake further research on this project and is the University of Waikato Creative New Zealand Writer-in-Residence in 2013. I thought I'd just tell my personal story of how I was introduced to Professor Sharp's work on our patterns of thought in New Zealand's law and politics. I was an undergraduate law and sociology student trying to make sense of the demands that the Treaty of Waitangi placed on our state and society. At some point, I happened on a book entitled Justice and the Māori. It was difficult in the sense of being long and detailed and discussing complex issues. but it was crystal clear in its meaning. It provided the historical and intellectual context of Māori claims to justice. And it discussed these issues at a level of analysis that I hadn't seen before. And it made sense. I remember being awestruck. Someone can make that out of the jumble of historical and political and legal materials relevant to these issues. Going from the ideas of justice found in government reports, to the writings of Māori sovereignty activists, to Robert Nozick, to Court of Appeal judgments, to Prime Ministers, to myriad editorials and letters to editors, to Waitangi Tribunal reports, and making sense of each vision of justice that these put forward. I can remember thinking, these insights are hard-won and precious. It's a wonder that somebody can do something like that. So we're very lucky that Professor Sharp can make sense of political thought and our political traditions in the way that he can, and we're very lucky that he's going to address us today on the idea of tradition. So please join me in welcoming Professor Sharp.
I've got what looks like a bar stool here, which I'm going to sit on. If it gets too bad, I'll reach for a beer. Kia ora tātou. It's traditional and customary that a paper giver should begin by outlining the paper's argument, but I'm going to follow another tradition by beginning in the middle of things. My point of departure will be in early modern England from about 1600 until Edmund Burke published his book called An Appeal from the New to the Old Whigs in 1791. It was there and then that the idea of the English Constitution as customary and traditional emerged and reached its most eloquent expression in Burke. In speaking of this tradition, of some of its competitors, and of what this might mean for New Zealand, I should state that the scholarly world learned much about these matters from one of the most distinguished of New Zealand scholars, Professor John Pocock. I wish to continue this tradition. In Roman law, traditio was a person's handing over something to another. The act could register the transfer of ownership with legal validity, but only under certain circumstances. The mere act of delivery transferred title only when there was just cause that it should. Delivery without title was void in law. Since then, of course, the idea of tradition has taken on multiple meanings. The metaphor of handing on, delivering, or presenting has been greatly elaborated. It's applied to the means by which not only individual physical things are transferred to and from individual private persons, as in much of Rome's history, but to collections of things and persons. It's applied to the handing down of single ideas and to collections of them. It's applied within the ambit of arts, sciences, disciplines, and all mysteries. It's applied to the inheritance of customs, manners, and laws by cultures and nations as a whole. So that, for instance, tikanga Māori can be seen as custom or tradition, as a compound of practices and understandings handed down through the generations. It's sometimes a cause of contentment that particular traditions should be as they are. Tikanga Māori is one case in point. Tika very often just means right. To give another example, lawyers in New Zealand attend to lines, that is to say multiple traditions of cases, which they take to be authoritative in the appropriate field of application. Very often, they too think that what is lawful is also right. In contexts like these, tradition guides or even demands particular judgments and actions. On the other hand, traditions are sometimes bitterly resented by those who wish to throw off their shackles. Certain Englishmen in the 17th and 18th centuries wished to free themselves from the Norman yoke of kingly, priestly, and oligarchical government. They argued that the regime they found themselves living under was indelibly stained by its origins in conquest and its continuance in unjust domination. Such talk is not unknown among Maori New Zealanders. Traditions, then, even while they flourish, may encounter opposition, and they can decline and die too, as did the counter-tradition of the Norman yoke. But traditions are not always or so easily thought to have identifiable beginnings. Today, we know that they can be deliberately invented, as well as emerge into the light at particular times, deliberately intended or not. Even so, some traditions not only have been, but are still held to be immemorial. They're thought to have existed beyond the time which the memory of man no man goeth. In 1612 dedication to his Irish reports to Lord Chancellor Ellesmere, Sir John Davies took out the time to spell why. For the common law of England is nothing else but the common custom of the realm. And custom which hath obtained the force of law is always said to be jus non scriptum. It cannot be made or created either by charter or by parliament, which are acts reduced to writing. For a custom taketh beginning and groweth to perfection when a reasonable act, once done, is found to be good and beneficial to the people. Then do they use it and practice it again and again, and so by often iteration and multiplication of that act, it becometh a custom. And being continued without interruption, time out of mind, it obtaineth the force of a law. In Davies' view, then, nothing was a law in England but tried and tested custom, subsequently declared to be law by those in authority. He therefore imagined the law as a whole to be so framed and fitted to the nature and disposition of this people, as we may properly say it is co-natural with the nation, so as it cannot possibly be ruled by any other law. It represented, he said, the wit, reason, and self-sufficiency of the people. There was no need to borrow from the lawyers and philosophers of Greece or Rome. It was the peculiar invention of this nation and delivered over from age to age by tradition. For the common law of this nation is a tradition and learned by tradition as well as books. Chief Justice Cook, one of the same generation of common lawyers as Davies, could not also but observe with Davies that many statutes which had injudiciously altered the common law had had to be repealed. This led him to the further thought that custom, now specified to be judge discovered, was much more to be relied upon by any law made by any act of the present generation. Writing on Calvin's case, he famously declared, "We are but of yesterday, and had been ignorant if we'd not received light and knowledge from our forefathers. And our days upon earth are but as a shadow in respect of the old ancient days and times past, wherein the laws have been by the wisdom of the most excellent men in many successive ages, by long and continued experience, fined and refined, which no man, being of so short a time, could ever have effected or attained unto. No man, therefore, ought to imagine himself wiser than the laws. The artificial reason, he called it, of the law was even more to be trusted than the natural reason of an individual or an assembly. The intellectual authority of judges arose very largely because of their reliance on artificial reason rather than their own imaginations. The law was immemorial, yet it was also constantly changing. To a modern mind, this might seem a paradox, but it was one resolved by the idea not only that any alleged changes embodied in the findings of courts were simply declaratory judgments of what the law already was, but that statutes were the same. I'll just stop for a moment. Where I'd got to is I was talking about an English tradition of thinking about laws, a tradition in which the claim was that laws were really nothing but customs which had existed time out of mind. A custom was nothing but an action or a practice continued through time, tried and tested by the people of the nation. After it had been tried and tested and found to be good, at various, again, unstated points, judges or people in authority would discover these customs and pronounce them to be law. They always had been. It followed from that what judges were doing was simply declaring what the law and or custom of the realm was. So they weren't making up law as they went. They were discovering what was there. And the same went for statutes or declarations. These weren't making of laws, but discovery of what was already there, made by the people. For this reason, judges were thought to be wise because they exercised the artificial wisdom of their ancestors contained in these customs and laws and didn't rely on their own particular thought or imagination. I then was saying the law was immemorial yet constantly changing when John had his trouble, so I'll go on from there. The law was immemorial, yet it was constantly changing. To a modern mind, this might seem a paradox, but it was one resolved by the idea not only that any alleged changes embodied in the findings of the courts were simply declaratory judgments of what the law already was, but that statutes were the same. During the 17th and 18th centuries, it was constantly insisted that Magna Carta, the great charter of the liberties of England, was not the creation of a single act in 1215. It was simply the summing up of what was already there, as were its 30-odd confirmations down through time. The lex terrae, that is the law of the land, was an inheritance. It was the product of no living person or institution. The next thing to see is that this law came down as an indivisible whole and was the property of everyone, so that Cook was able famously to say that Magna Carta is such a fellow as he will have no sovereign. The lex terrae, that is, was prior not only in time, but in moral weight to all governing institutions, as well as the current generation of people. The body of laws was to be found in the enormous collection of documentation in the records of the Tower of London. But emergencies demanded from time to time that it be summarised and shaped for present purposes. In 1642, for instance, the Greco-Roman Venetian formula that England was a mixed monarchy made up of 3 estates of king, lords and commons was adopted to describe and prescribe for the relationships among the 3 great contending institutions. This description, inconveniently for those who supported them, forgot the ancient estate of the bishops and suppressed the old knowledge that the king was not one of the estates, but head of the estates. Another summary expression of the relations between the great governing powers was the theory promulgated by such people as Montesquieu and Delome, that there was a division between the executive, legislative and judicial functions of government in England that mapped onto the separate institutions. This was highly inaccurate, both as to legal fact and political norm, though it did point to the legal reality that the king held prerogative rights, that the 2 houses of Parliament shared the legislative power with him, and that the Lords held the supreme judicial power. However it was presented, though, the ancient constitution was not easily thought to harbour a single sovereign power whose will was law. The mixed and balanced constitution, duly analysed, critically examined and often misunderstood, was the one much admired in the rebellious 13 colonies and in Europe well into the next century. But whether the ancient constitution was theorised in such summary ways, or known in the fullest possible detail, appeal to it during the civil wars and other crises of the 17th and 18th centuries proved in the real world to provide no solution to disputes over the lawful power of final determination within the Constitution among the governing powers. Histories and theories abstracted from a variety of times, places and views of human nature were developed to show that sovereignty lay either in the king or in the Houses of Parliament. But thoughts of concentrated unitary sovereignty were never comfortable ones to entertain. There was widespread abhorrence of the idea that any institution should be the final arbiter in their contentions. And so the idea of a customary constitution that knew no sovereign kept its grip. The Petition of Right, 1628, asserted the inherited legal rights and duties of all. Kingship was restored after a revolution in 1660 in the name of an ancient and mixed constitution. The Bill of Rights of 1689 was hammered together as a political solution to an insoluble constitutional breakdown. In a pious fiction, it was asserted that James II had abdicated rather than being frightened off by the threat of armed force, and to insist that the actions of an unconstitutional convention parliament were designed only for the preservation of the ancient rights and liberties of the people. Burke, therefore, did not have a difficult task to show all this in his appeal from the new to the old Whigs. In that book, he held that the old Whigs of 1689 were common law traditionalists. The new Whigs, who spoke of natural rights, like the French revolutionaries, were mere theorists, dangerously ignorant of the reality of things. In John Pocock's gloss, they were middle-class intellectuals, tempted to believe that they could proclaim governments illegitimate without anyone getting hurt in the process. They arrogantly claimed that all men had natural rights and that they could be governed only when they had contracted to put themselves under government. Worse still, they claimed the continuing existence of government depended on the people's continuing consent. The people retained, that is, the right to cashier governments. In his more famous reflections upon the revolution in France, written a year earlier, Burke had put a similar line of thought in a more baroque fashion. He orchestrated a counterpoint of themes in which the magnificent order of the ancient constitution was given body. You will see, he tells his reader, that Sir Edward Coke, the great oracle of our law, and indeed all the great men who follow him to Blackstone, are industrious to prove the pedigree of our liberties. They endeavour to prove that the ancient charter, the Magna Carta of King John, was connected with another positive charter from Henry I, and that both were nothing more than a reaffirmance of a still more ancient standing law of the kingdom. In matter of fact, these authors appear to be in the right. But if the lawyers mistake in some particulars, it proves the position still more strongly, because it demonstrates the powerful predisposition to antiquity which the minds of all our lawyers and legislators and of all the people whom they wish to influence have always been filled. The stationary policy of this kingdom, he said, has always been to consider the most sacred rights and inheritance we have as an inheritance. Understandably, therefore, Burke saw jurisprudence as the pride of the human intellect. It nurtured, adapted, and transmitted man-made law. But its method of proceeding, he argued, was also in accord with divine and natural law, the general principles of which were interpreted and applied case by case to the specific needs of England. Jurisprudence, he thought, with all its defects, redundancies, and errors, is the collected wisdom of the ages, combining the principles of original justice with the infinite variety of human concerns. And so, our political system is placed in a just correspondence and symmetry with the order of the world, wherein, by a disposition of stupendous wisdom, moulding together the great mysterious incorporation of the human race, the whole at one time is never old or middle-aged or young, but in a condition of unchangeable constancy moves on through the varied tenor of perpetual decay, fall, renovation, and progression. Thus we preserve, he said, the method of nature in the conduct of the state. Only necessity, according to Burke, can justify violating this condition of things. But it's that first supreme necessity only, a necessity which isn't chosen but chooses, a necessity that's paramount to deliberation, that admits no discussion and demands no evidence. He echoed Sir Matthew Hale's History of the Common Law, written in 1675, holding that one should approach the faults of a state as the wounds of a father, with pious awe and trembling solicitude. That's the end of the first section, and that's supposed to conjure up how these people thought. Where rites and ceremonies, the nature and purpose of which are not verbalised, are handed down, they're likely to be longer lasting than verbal traditions. With words come the possibilities of observing ambiguity and contradiction in traditions, and of realising that there are aspects of things that they don't speak to. Their more energetic inheritors typically attempt to suppress, reconcile, or accommodate these embarrassments, and in doing so bring about evident changes to those traditions. When, by way of additional challenge, traditions are recorded in the written, not just the spoken word, the truth of their factual bases and their normative force become even more vulnerable to appraisal, modification, criticism, and rejection. Like John Pocock, my other main authority on tradition, Professor Edward Shills, notes these recurrent phenomena when traditions are formulated for explication and defence. Now, clearly the ideas expressed in defence of the ancient constitutionalist tradition were a complex series of propositions formulated in written words. They were also propositions formulated in the midst of contestation as to their truth and moral force, and were designed to deny other accounts of what the Constitution was or ought to be. But much of this, of course, would have been lost to contemporaries. Shills might have been contemplating how ancient constitutionalist thinking in England presented itself to its recipients when he remarked, though with more general reference, the tradition, the thing presented, appears at the moment of its presentation as a telescoped, foreshortened picture from which the history of its past career has been washed away. The naked eye can only see it as the moment here and now. It doesn't see the layers of past experience and perception and past reflection which shaped it throughout its history. The picture at the moment is a precipitate made up of many successive presentations and receptions and representations over many points in time. The individual who acquires the idea takes his place in the sequence of those whose minds were taken into possession by what they saw before them. As Paul McHugh has argued, it was exactly in this foreshortened way that the great jurist Albert Venn Dicey, in 1885, characterised the constitution of the United Kingdom that New Zealand had inherited in 1840. Constitutional thought having been modified to encapsulate a new liberal Whig consensus, Dicey could now understand history and law to be separate disciplines. There was no controversy, there was no need of historical understanding to get a grip on the two pillars of the British Constitution. It was, like the old Whig Constitution, a tissue of common law arrangements, inherited from time out of mind, but it was now unequivocally also thought to be protected, sustained, and where necessary modified by the legislative sovereign will of the Crown in Parliament. This was a Hobbesian sovereign in idea, even if that sovereignty was shared among institutions. Because there was no controversy, there was no need intrinsic to their discipline for constitutional lawyers to understand the uncertain and contested origins of the Constitution. They didn't need to recall royalist, parliamentarian, Whig, Tory or Jacobite assertions that its origins lay in the will of the king, or, contrawise, in an agreement of the people. There was no need either for them to examine the proposition that authority in origin, at the beginning, implied, through tradition, authority in current practice. And so they could ignore the conflicts that had led to the successive developments of the idea of mixture, balance, and separation of powers. There was even less need to consider the demolition of the foundations and continuance of the Constitution by Jeremy Bentham, say, at his most rationalist and analytical. After all, one of Bentham's disciples had revivified the theory of legal sovereignty. Others had transposed the problem of seeing the people's power over the Constitution by seeing it as one answered by their representation in it under the law. Dicey did, of course, consider the inescapable power of the people at some length. He said they held political sovereignty, that is, the greatest de facto power in the country. But that power did not have the authority to create valid law. As for Dicey, most significantly for all New Zealanders who inherited this tradition, there was no gainsaying the right and power of Crown and Parliament to make law, and there was no way of questioning the process by which ideals of majoritarian democracy and liberalism came to modify the location of that supreme power through time. This view of the Constitution clearly and most spectacularly governed the minds of those who abolished the Legislative Council in New Zealand in 1951. It may be that it was the PM and Cabinet who then, as now, dominated government, but their constitutionalism put it otherwise. Governments ought to represent the people. The Legislative Council didn't. There was therefore no need for it. So the second doomed chamber was stacked with compliant members and engaged in the valid process of its own abolition. The royal consent was a mere formality. The House of Representatives was supreme. The statutory reforms of the Constitution, beginning in the 1970s, breathed the same spirit of confidence in a representative sovereign legislature, even though the spirit of ancient constitutionalism remained active in other areas of law and continued to add its weight to the idea that the sovereign should be checked and balanced, or, as it has been put more famously in New Zealand, bridled. Equally demonstrative of the workings of the two pillars of sovereign legislation and common law, the principles of the Treaty of Waitangi were incorporated into the body of law. Matthew Palmer's book, The Treaty of Waitangi in New Zealand's Law and Constitution, relates the recent story and its outcome. But Maori concerns have also been dealt with in another way from the beginning of the relationship between Maori and the Crown. The Crown used its ancient prerogative power to authorise its servants to negotiate with Maori to address unsettled business, whether under the treaty or otherwise. And Maori, as well as undertaking legal proceedings, were very capable from the beginning of negotiating with whoever had the power to help them. There were negotiations in all kinds of nooks and crannies. What happened was not always justiciable, but was allowed for in the legal condition of things. Mark Hickford's tried to capture this complexity in the phrase political constitutionalism. In the last resort, though, the interaction was Diceian, under law and ultimately controlled by Parliament. Section 3. Today, the Cabinet Manual expertly and pithily advises ministers and other interested parties how the Constitution now works. It could hardly have been done better. However, it's one thing to give an up-to-date and practical account of the law and working of the Constitution. It's another to understand what a foreshortened constitutional tradition expresses and suppresses about its own history and reasonableness when it's mobilised not to yield a summary of, but to legitimate present arrangements. That kind of understanding would be one kind of unearthing of a tradition. It would be one that revealed a massive detail and critique, not all of it compatible with an easy acceptance that the Constitution is what we happily inherit. An imagined student would go to the past, not like a lawyer to find authority for a current distribution of rights and duties, but rather to create a convincing image of the complexity of what actually happened in the past. The student might well ask what caused the legal authority to be and how currently authorised distributions came about, but equally the student might criticise the whole tradition as far too constrained to speak of the complex reality, the complex density of past realities. The student with the spade would certainly not produce what I elsewhere called juridical histories, that is to say, histories that are aimed at shaping the past for purposes of advocating present cases. But rather than unearthing our official constitutional tradition in this kind of way, I intend to bring to view here a series of other constitutional traditions that also inform debate in Aotearoa, New Zealand. I propose to expose to light 3 of these so that they too are potentially available to critique. The 3 are what I call the Māori tradition, the whakapapa tradition, and the universalist tradition. Here I can present them only in a very rough semblance as to their true shapes and masses. The subtle accretions of the real world that cling to them as they are lifted into the light of observation will obscure their internal subtleties and their symbiotic connections. Unearthing and separating is a messy and sometimes arbitrary business. Still, I intend to introduce nothing new in unearthing the traditions in this way. All that will perhaps be unfamiliar will be that at certain points I will use the idea of the constitutive power of the people. This will stand for what we sometimes call, among other meanings indicated by the usage, sovereignty, mana, or rangatiratanga. It's the normative power which in England was thought of as that of constituting and cashiering not just this or that governing power, but governing power as a whole and governing powers in general. Maori constitutionalism, of uncertain time of origin, but formed largely in counterpoint to the constitutionalism of the European colonisers, asserts the ancient existence of a people who came to these islands with their customs and traditions. They modified their view of the world through time to adapt to their new homeland in ways that can be known in Mataranga Māori. Often the ideals harboured in their worldview have been summarised in lapidary form as including the principles, for instance, of rangatiratanga, kaitiakitanga, whanaungatanga, and so on. Principles which governed their leaders, their protective relationships with nature, and their ties of kin. From a constitutional perspective, though, the critical point is that the people brought with them and continue to have a constitutive power. That is, the right to erect a government of their own and or to federate within themselves or with a government not originally theirs in ways only they themselves could decide upon. And so, in 1835, the story goes, they were entitled to declare their independence from all other peoples and powers and to begin a process of constructing a government for themselves. In 1840, in the Treaty of Waitangi, they exercised their constitutive power in a different way so that they could enter a form of government guaranteed the protection of Queen Victoria. According to the terms of the contract with the Crown, they retained their rights to govern themselves in their own groups, in their own localities, and according to their own ways of seeing and doing things. This was their contract. To call the treaty the foundation of the New Zealand Constitution, in this way of thinking, is not simply to use a form of words to show the great weight of the treaty in the body of our law. The treaty was, in constitutive truth, the foundation. It contained the mana of its makers, translatable in this context as their constitutive power, their right to set up or join any government they chose. That foundation, in turn, was rooted ineradicably deep in the ground. As tangata whenua, the people of the land, the Māori retained the constitutive power to ensure that the foundation which they built should be preserved and developed in ways they chose. Many variations on Māori constitutionalism have been developed on this treaty foundation. The variations, as you all know, run the gamut from the claim to complete Māori independence through elaborated schemes of power sharing at strategic central and local sites of authority, through to adjustments in the detail of arrangements regarding local and tribal government over a range of issues and resources. Now, as official constitutionalism has proved capable of absorbing all external traditions, so has Māori constitutionalism. It has found rangatiratanga, kawa and tikanga. It has found in those concepts the principles of good governance, of commercial institutions, and of the many other voluntary organisations that Māori join. It's absorbed international human rights law into its ambit, including the Declaration of Rights of Indigenous People. The most influential author, perhaps, and transmitter of such teachings has been the Waitangi Tribunal, but many other organisations and persons, Pākehā as well as Māori, transmit it. It's a firmly settled tradition of understanding. I think it's at least as dominant as the official constitutionalism, which is the constitutionalism of the legal specialist. By beginning my paper with an account of the English tradition of constitutionalism, and then moving from what I know to what I know far less about, I've inevitably modelled my understanding of tradition and constitution on European understandings. A leading Māori constitutionalist, Moana Jackson, is surely right, though, to insist from within the Māori tradition that reflections on constitutionalism should begin not there, but instead with an understanding of kawa. For me, he says, a constitution is just a kawa, or the rules of the people, or the rules that people make to govern themselves. The kawa of the marae is the constitution of the marae. It's the rules that govern how people should behave on the marae. Where I have found myself conjuring up fragments of a picture whereby the customs of the people of England, produced among the anonymous people of the localities, were absorbed and modified by a unitary government and then dispersed through the three kingdoms to the British colonies and ex-colonies, Jackson asks his audience to imagine a constitution that begins with the kawa of a marae. The kawa governs both its internal and external relations and is to be imagined extending to cover the whole of Aotearoa, all the marae and all the people. In fact, he argues, this has partly happened despite the obstacles it's faced. Tikanga reality, as he calls it, is as much a reality as legal reality, and he thinks that ideally tikanga reality should provide the groundwork of constitutional debate. He finds it hard to see why kawa should be overridden by Pākehā traditions. The constitutional conversation of which the state speaks should take place on that turanga waiwai, on that foundation ground, not the Crown's. I, however, must continue to speak as a mangai for the tradition that has me in its grip, as Shills puts it. So far as I can see, the tradition of Māori constitutionalism lacks a conception of a single sovereign power intrinsic to government. It envisages no locatable authority whose right it is to pronounce with the force of final judgment on what's to be done. Neither can it envisage an authority, however eminent, that is not subject to the constitutive right retained by the people it represents. This rejection of a Hobbesian sovereign is obvious in regard to the Māori constitutional history of Māori and the New Zealand state. But I think it's equally obvious within what used to be called Māoridom itself. The tensions this unextinguished constitutive right causes points to another kind of constitutionalism found working against as well as within Māori constitutionalism, and I call this whakapapa constitutionalism. Many attempts have been made by Māori to express mana Māori motahake and kotahitanga in a variety of collective organisations, but in none has the constitutive authority of the separate members been irrevocably ceded to any organisation. The iwi, hapu and whānau retain their rights to secede as well as their rights to represent themselves in the councils of their shared creation. The tradition is that iwi, hapu, and whānau come together for certain purposes and go their own ways for others. This expression of whakapapa constitutionalism is, like Māori constitutionalism, an expression of kawa and tikanga, but it stresses rather more the rights and duties of whakapapa, the mana transferring genealogy of particular lines. In the mix of Māori and whakapapa constitutional traditions, the ties of blood and consent mingle in complex ways depending on the collective action in question. As Apirana Mahuika, one of my authorities on this, has put it, the principles of fusion and fission are very much alive today. Now, if there is any indissoluble fusion, it's only in the whānau or perhaps the hapu and its family marae. In this way of thinking, it's not a tradition of being Māori that matters, so much as a tradition of being descendants of a particular ancestor. The fundamental group of the whānau or hapu retains a constitutive power to join and recede from all other collective institutions. So do individuals, who usually, of course, belong to more than one whakapapa group. Whakapapa groups, to this way of thinking, are the fundamental constituents of any Māori authority. No external judge may discover or pronounce on their ways. So, as Māori claim a constitutive right in the Constitution of New Zealand, so do whakapapa groups claim constitutive rights within Māori. The fourth and final tradition of constitutionalism in New Zealand might be called universalist. This is best understood, perhaps, as the modern attempt to find and apply a jus gentium, a law to govern peoples generally and not just those of a particular single state or people. It's thought that this attempt is justified both because most peoples in fact agree on the broad principles which express its content, and also because its principles are reasonable, that is, they're discoverable by reason, and if applied, tend to the benefit of all. In its modern form, jus gentium prescribes human rights rather than the natural duties of the Burkean tradition, and it speaks of the rights common to all rather than the rights and duties of individuals and groups specified in the detail of a kind of Burkean way of understanding natural law or in the municipal laws of a state. The Civil War levellers in England, Tom Paine, the French and American revolutionaries, and since the middle of the last century, the United Nations Declarations of Rights are informed by some such notion of natural or human rights. So too are the ideas of those often who would have a Bill of Rights in New Zealand, a Human Rights Commission, and a written constitution. The main thrust of this tradition is firstly to counter the grip of local traditions on peoples so as to free them from the invidious distinctions they make between classes, castes, religions, races, genders, and so on. Secondly, it's to invoke the power of human reason to critique the very idea of being dominated by a tradition. Universalism, of course, has not been received uncritically. It's opposed, for instance, in China and India and in many Muslim states as an attempt to impose Western ideas on ancient societies who feel their own traditions sufficient for themselves. But many states have proved capable of absorbing and domesticating the tradition of universality. The declarations of social and economic rights were long thought, even in the West, to be too difficult to apply to peoples as a whole and too subversive of property rights when they could be applied. But even they have been drawn within the ambit of local law. So has the tradition, so has the Declaration of Rights of Indigenous Peoples. It sits uneasily within the tradition of liberal democratic constitutionalism because while its principles propose benefits universally to Indigenous peoples, they don't do the same for all peoples generally. And so governments took some time in New Zealand to come to terms with it, but they did. On the other hand, Māori were at first uncomfortable with its treating their unique case as only one case among many others in the world. Still, the declaration has been accommodated and is now spoken of as expressing human rights and not just special rights in a unique state. Final section, I must now, as is customary in New Zealand, draw a practical conclusion. I will therefore end as I began, in the middle of things, but not now in England in 1612, but in Wellington in 2013. New Zealanders embrace a number of constitutional traditions. Each tradition implies different constitutions. Different conceptions of justice are sustained in those traditions, and different attitudes to the constitutive power of the people. I have no doubt that dialogues among these traditions are called for, and for truth-telling in conditions of stability and safety. But to know traditions and to treat them all with respect is not an easy thing. Bringing things to the surface can be a dangerous condition. For myself, I very much doubt that the current constitutional conversation should lead to any more than its own continuation. I'd be very cautious of embracing any idea that to consult the people on their constitutional preferences is in any way to recognise their constitutive power, and I'd be even more chary of the least thought that the power might be set into motion by a referendum to legitimise any new constitution. Why be cautious? Well, to put it one way, traditions are traditions among fairly definite groups of people. The traditions they believe in have them in their grip. To put it another way, there are separate interpretive communities carrying on conversations, each with their own authorities whom they defer to and quote, their own interpretations of things, their own perhaps esoteric languages, and their own agendas. And so the dialogue might be imagined to be between communities and not among individuals. But I think that members of each of our constitutional communities might put it yet another way. They might say of the idea of a constitution, this is my body, or this is my body, and emphasise each of those words in different ways. This is very evident in the cases of Māori and whakapapa constitutionalism. The imagery of iwi and hapu and whānau exactly expresses the inescapable reality that each individual is an embodiment of them. His or her identity, as we very clumsily say, takes its form and meaning from placenta, birth, and bone. Because of a long history of living in a disenchanted world of many competing traditions, official imagery speaks with less living force of the Constitution, the body of the law, heads of departments, members of organisations, and so on. But I still think it's a manifest reality that the various constituted officers of government think of themselves as responsible for the lives of the people they govern and serve. They're part of a body too, expressed in the idea of a nation. By contrast, it's evident that the tradition of jus gentium, in its domestic application, seeks somewhat to deny or suppress such thoughts, perhaps with good reason, because what the body imagery must surely bring to mind is that constitutional conversations are not merely conversations with words. Meanings come to us embodied in persons. We're dealing with real bodies, real presences, not just abstract human beings. And conversations can lead to quarrel and a breakdown of peace, which is the condition of justice and all the other civic virtues. But all human beings, as the jus gentium insists, must be protected, not just nations and peoples, and so the emphasis must go on our common humanity. Hobbes, seldom a hero of constitutionalists, but whose Leviathan he intended to protect and nurture all, put it this way: pointing to features of human existence denied in none of our local traditions and features that make civil constitutions necessary. In the nature of man, he says, we find three principal causes of quarrel: competition, diffidence, that's fear, and thirdly, glory. Competition maketh men invade for gain, fear for safety. Thirdly, glory makes men compete for reputation. The first, people use violence to make themselves masters of people's persons, wives, children, and cattle. The second, out of fear, defend them. The third, and this is the one that matters here, quarrel for trifles, as a word, a smile, a different opinion, and any other sign of undervalue, either direct in their persons or by reflection on their kindred, their friends, their nation, their profession, or their name. Accepting as I do this appraisal of mankind, I don't think that discussions that raise issues of sovereignty, the constitutive power of the people, and the importance of people's customs to them should be pursued to a definite conclusion, especially in an abbreviated written or rigid constitution. At best, the product would be a single constitutional document that left out far too much of reality, and it would almost certainly risk injury and insult to those who felt themselves disrespected. Respect for other peoples and their traditions, whether generated in fear or love, demands that we approach the Constitution like an ailing father, with fear and trembling solicitude. I'll just read a last paragraph and then stop. To approach policy and organisational problems one by one, wherever it seems convenient, is a different matter. New Zealanders often castigate themselves for the pragmatism with which they approach constitutional as well as other questions. That pragmatism is ancestral and ought to be current wisdom. It is wise to attend to the arrangements of society piecemeal in every local and specific case, and nationally when it must be done. It's not wise for leaders of teams of action in the country to engage in grand constitutional theorising, ignoring the wit, reason and self-sufficiency of the population, especially when the population says it does not care. Most people in New Zealand do not wish to examine what constitution they've inherited, to think what constitution they would rather have, and to ask how it might be legitimised. The cleristes, the bodies of experts who do care about these things, cannot agree on a grand scheme. So, what's the benefit of searching for one? Is there some necessity that can't be denied? I say, let community and government leaders continue in a tradition of political constitutionalism, and let's not worry too much about reducing any account of the Constitution exclusively and misleadingly to superficial legalities. Thank you very much.
Thank you. Well, sure. So thanks, Professor Sharp, for that rich and stimulating meditation on the idea of tradition and the tracing of a number of different traditions that exist in this country. We have, I think, Claudia said 11:15. So let's have 5 minutes for questions and comments, and if you just raise your hand and introduce yourself before you ask your question.
Oh, Les, what a surprise.
It's really an internal question. I found your argument fascinating and subtle, and obviously can't do justice to it. But I was puzzled by one element of your analysis, and that was the analysis of the Maori constitutional tradition, or the first of the alternatives. Because I think it's quite important to get that right. And the thing that worried me about it was that when you said it lacks the conception of a single sovereign
I use the analysis of constitutive power of the people, and the core idea is that if a people has this power, they can then construct their own constitution. But another way to look at it, which John Pocock has done too, is to consider that this is a federative power, that is to say the right to join other pre-existing organisations and federate with them. I think that what's happening in the Waitangi debates is that it's the federative power that they're using to join with an existing power, the Crown. And so I don't see the problem really. You see what I'm saying? That they retain the constitutive power still. It's still a federative power. They could withdraw from agreement with the Crown if they wanted. Don't see why not. It is, yeah. Well, this is kind of covered in my phrase political constitutionalism, really. I think everyone in New Zealand recognises powers that are actually there and recognises their legitimacy, really, and will act through whatever sources seem reasonable to get what they want. Everybody does this, and I can't see any reason why Māori in constitutional thinking shouldn't recognise that for the time being. However, if anything went really wrong, Māori constitutionalism as a theory, which I've kind of developed, would be perfectly capable of saying, well, then Parliament isn't legitimate. We'll cashier that government and set up another. That's all. People that believe in the constitutive power of the people will often go on with governments for a tremendously long time. I mean, John Locke, who used the idea of the constitutive power of the people, was actually a very conservative political thinker, merely wanted to stop the king using the suspensive and various powers of the prerogative, and so he invented quite a complicated way of getting through this, and didn't call on the constitutive power of the people till the very end. And so I don't think it's an ever-present threat of constitutive power being used, but it's just a theoretical concept. But my idea, by beginning with the idea of a constitution as going back time out of mind, is that it gives no one this kind of power. It doesn't give any institutions within government a sovereign power. The stuff is actually spread everywhere. And it doesn't give the people a constitutive power either, the right to set up and pull down governments. The point is, everyone is captured in an incredibly complex cake of custom and habit and ways of action, which none of them are free to break through and reconstruct. They don't have the authority. There's no way of finding an authority within that structure that could do that. Now, I'm not saying this is true. I'm saying this is the way English constitutionalism was at the height of its traditionalism. And I think Māori constitutionalism has a lot in common with that, except when it finds itself faced with constructing powers, and then it begins to think about constitutive power. I put it too briefly, I'm sorry, but I better stop in case someone else has something.
Well, I think we don't have any time for any more questions, but let's have one more anyway.
It's the most incoherent philosophy I've ever heard of, really, so I'm not about to defend it. But I really think that if you get a practical problem, you can then put all your resources of philosophical thought into it and analyse the problem in the greatest possible detail you can. Like Jeremy Bentham, you cut it up into its parts, you find out the empirical research and things that go with it, and you move that way. And then secondly, you can do a little bit of what I was doing there, say to yourself, well, even if we did that and technically we worked out what would be the best thing to do, we would still have to hesitate because there are people's souls mixed up in this. Not just their interests, but interests are of course very important, but their very being is mixed up, so you have to be careful. Now I think that's the kind of pragmatism that in New Zealand we mostly do, and that's really all I meant by it. I don't want to do an analysis of Emerson or anything. No.
Okay, so we're going to have to continue these discussions and questions and comments with Professor Sharp outside of this session, but before we do so, I'd like to, if you'd join me once again to thank him for his talk. Okay, so we're still taking a 10-minute break? 7 minutes.